Good afternoon, and thank you again for joining us for today's webinar, 10 Years of Conservatorship, Successes, Challenges, and Next Steps. Today's presenters are Winnie Branton, Michael McIlhinney, Sabreena Woods-Miller, and Alicia Karner. I'm going to turn the presentation now over to Winnie.
Good afternoon, everyone, and thanks for joining us today. Conservatorship, as many of you know, is a tool to address long-term vacant and abandoned blighted properties in Pennsylvania. In short, it allows a third party appointed by the court to enter another property and make repairs to bring the property up to code. Today we are going to talk with a number of folks who have some experience in researching and actually using the tool in parts of Pennsylvania. And I am excited to be here today because the Housing Alliance had issued a report in the spring of last year, and one of the needs that was identified in the Revitalizing PA report was the need to promote greater use of existing tools to address long-term vacant and abandoned blighted properties. And in that recommendation, there was also some practice recommendations, and one was to increase knowledge of the effective use of conservatorship, and the second was to gather and share success stories. So today we're going to do both of those things. We're going to talk about the basics of conservatorship, and we're going to share some success stories from across the Commonwealth. So I'll just give you a brief introduction of our speakers. Myself, I'm a consultant to local governments and nonprofits, and I work closely with the Housing Alliance on providing blight training and technical assistance. Michael McIlhinney is an attorney in Philadelphia with Orphanides and Toner, and he's an experienced real estate practitioner and has done many conservatorship actions in Philadelphia and the surrounding area. Alicia Karner is the Director of Community and Economic Development for the City of Bethlehem. She has experience across county, local, and legislative branches of government, and we're happy that they can both join us today. And we also have Sabreena Woods-Miller, who authored a report for PCRG in Pittsburgh that looks at 10 years of conservatorship. And we're so happy that Sabreena could join us today, too. So we're going to start off with the basics. Michael's going to cover that. I'll share some statewide data and analysis that was part of a research project I supervised, and then we're going to look at some examples from Philadelphia, Bethlehem, and Pittsburgh. So right now, I'll turn it over to Michael and ask you to proceed. Thanks, Michael.
Thank you, Winnie. As Winnie said, my name is Mike McIlhinney. I'm with Orphanides and Toner in Philadelphia, and I'm going to give you an overview of what the Act is and how it's applied. So I'm going to change I actually don't have control of the slide. If somebody could select the next slide for me. There we go. So when we're dealing with abandoned and blighted properties, the Act is known as the Abandoned and Blighted Property Conservatorship Act. And notice it doesn't say just vacant. It's abandoned and blighted are the criteria, the overarching themes of what has to be established to bring one of these properties into conservatorship. And the third screen. There it goes. Sorry, I'm having a little trouble clicking the next screen. The common scenarios that we see where properties become abandoned and blighted, a lot of them are estate-owned properties where an owner passes away without a will. The family doesn't know how to probate estate or chooses not to. And as the property goes through generations, it falls into disrepair, and the heirs don't have an ownership interest sufficient to warrant fixing the property, or they don't know how to go about clearing up the title. And they oftentimes, especially in inner cities, end up walking away from the properties. This often happens in neighborhoods that at one time the property values have been depressed and it's more expensive to raise the estate than the property might have been worth decades ago. And as neighborhoods gentrify and investment money starts falling back, a lot of this conservatorship tool has been a great way to bring those properties back to life. The other scenario is investor-owned properties, where people pick up properties at sheriff sale or just in the normal process of their investor business, and they just sit on it. They land bank the property with the intent of they're going to wait for the neighborhood to turn, but they're not going to be the one to invest before it does. And we see a lot of investors that kind of do the demolition by neglect routine and just wait and sit on the property if they acquired it for a low enough value. Can somebody click the next tab? Oh, there it goes. So in an overview, what actually is a conservatorship? The process is a court process where a petitioning party is requesting the court to appoint a third party, a person, an organization, the municipality, the school district, to take possession of a property that meets the criteria of being blighted and abandoned. And we conduct a trial where we have to prove our case that it is blighted and abandoned, and that a third party should be appointed to take possession to fix the problem, to remediate the blight. The conservator is the third party that takes possession, not ownership, and that's a point I always like to highlight. You don't get title to the property, you get possession, you get the keys to the house, so to speak, and then the conservator has to use their own money to remediate the blighted conditions at the property as approved by the court. There we go. So under the Act, it's a very broad definition of what properties can qualify for conservatorship. So the building is a very broad term. It's any residential, commercial, or industrial building, the land next to it, if owned by the same owner, and it also includes vacant lots where a building has since been demolished. Proving the abandoned criteria on a vacant lot is a little harder than obviously a building that's in a state of partial collapse. But vacant lots do qualify, and with the dumping that we see on a lot of properties, that's the type of vacant blighted condition that would warrant bringing an action against the vacant lot. So an abandoned building is specifically defined in the Act as meeting certain criteria. There's statutory prerequisites, there's 4 of them, and then there are additional, I'll call them discretionary criteria, and we have to prove 3 of 9. So going into the initial prerequisites before you can bring an action in court. So the mandatory criteria when a property is in an abandoned state, we have to first make sure that nobody's illegally occupied it in the preceding 12 months, that the current owner hasn't actively marketed for sale. And actively marketed means you're listing it on the MLS. You're really trying to move the property and take action to put it into somebody else's hands who can remediate the condition. There's no foreclosure action, so if a bank has already commenced an action to take the property back, the court doesn't want us coming in saying this property is dangerous and abandoned, nobody's doing something with it. If the bank's doing something, then that's sufficient with a foreclosure action. And if a new owner acquired it within the last 6 months, you also can't bring a conservatorship action because the new owner needs time to figure out what they're going to do with the property. There we go. And as I said, those are the 4 statutory prerequisites. Now the discretionary ones are all kind of interrelated. We have to be able to go into court and prove at least 3 of these of 9 discretionary criteria. And the first one, public nuisance, they all kind of encapsulate that concept of the property being a nuisance. It's one that hasn't been repaired and requires substantial repair in the past 12 months. It's not fit for occupancy, use, or habitation. It's an attractive nuisance to children. We often have properties that are unsecured against entry, which is a nuisance to the public. Kids get in there and can get hurt. It also leads to illicit activities, the vermin, increase of debris, and then a lot of times, I know in the city of Philadelphia and a lot of surrounding counties, if the owner doesn't seal up their property, the city will take it upon themselves, or the municipality, to board them up, and then they just put a lien against the owner's property for their failure to do so. So we have to prove 3 of those 9 nuisance criteria sufficient so that the judge can say, you know what, we need to have a third party appointed to take care of this abandoned building, basically. And who can bring one of these cases? Any party in interest is qualified to bring an action in court. And oftentimes it's a resident or business owner that's within 2,000 feet of the offending property, nonprofit corporations, or redevelopment authorities, any municipality or the school district. They all have the power to petition the court to bring an action. There is the additional requirement in Philadelphia that any nonprofit bringing an action actually has to have participated in a project within 5 miles. That requirement doesn't exist in the counties. Philadelphia, as the city of the first cast, just has additional requirements. So this is a basic overview of what the process when we bring a petition in court, what happens. So we basically file a petition with a party in interest, often a nonprofit, alleging that the property meets those statutory criteria that we talked about, the 4 prerequisites and then 3 of 9 discretionary criteria. Under the statute, the court will review our petition and then issue an order scheduling a hearing within 60 days of the petition being filed. We're then required as the petitioning party to notify all the owners, lien holders of record, the municipality, anybody that could be affected or have an interest in the property needs to be given notice. Then the court will hold that hearing on the appointment of a conservator, where we'd have to present all of our evidence as to why the property needs to be given to a third party, given possession to a third party to remediate the condition. And if the court finds it warranted, an order will be issued within 30 days. Generally, the court will make that decision at the time of the hearing, just because it's pretty obvious when you have a collapsing building or a dangerous building that if nobody's fixing it, then a third party should be appointed to remediate the condition. And at the end of that process, when the conservator gets appointed, fixes the property, it then will have to be marketed on the MLS and sold, at least in Philadelphia at this point, and the counties. The courts require it to be listed on the MLS and sold for the highest and best price. This property is the owner's property after all, so the court wants to ensure that the highest and best price is obtained, because at the end of the day, the conservator puts up the money to do the work, and they will be reimbursed all the money they put up when the property gets sold. They also will get their attorney fees covered, but the remaining proceeds get distributed back to the owner because they are the owner until the court orders the property to be sold. So what about the owner in these situations? Like, what rights do they have? So as I said, we must give them notice of the hearing when we file an action. They have an opportunity to come into court and oppose the petition, and in most cases the property clearly meets the conditions. They are very dangerous properties that we bring actions against. The owner does have the right to elect what's known under the statute as conditional relief, where they tell the judge and prove to the judge that they have the means and ability to remediate whatever the offending condition is, and then the judge will allow them to do that, but the judge will put them on a timeline to get it done so that it doesn't continue on in a lingering fashion. The owner also has the right to terminate the conservator, and to do so, the owner would have to reimburse the conservator, the petitioner and conservator, the costs incurred with bringing the petition. So the conservator brings the action with the intent they get reimbursed their costs for bringing the action, their legal fees get paid, and they also get reimbursed a fee for being the conservator, which is the greater of $2,500, 20% of the cost of rehabilitation involved, or 20% of the sale price. And generally that's the number that controls, is the conservator gets appointed, fixes the property up or demolishes it if necessary. The property gets sold, and the conservator's fee for doing that and taking on the project is 20% of the sale price. So the conservator's rights and duties. The conservator takes possession but not title to any property. They are just a third party appointed by the court to fix the problem. So the conservator can borrow money against the property if they get court approval. Generally, conservators use their own cash or a line of credit or some other means so that court financing is not needed to be approved by the court. If a project's taking a long time, you have to give a status update to the court of what's happening. And at the end of the process, you have to give a full accounting of all costs and expenses that have been incurred in the court process. And they also put in here, implement a final plan. So a conservator can just demolish a building, they could make a property into a safe, secure shell, or they could propose a full renovation into a new habitable structure. The statute gives broad array of discretion of what the conservator wants to do in any given case. The goal has to be to remediate the blighting condition, but you can do a full renovation and sell the property pursuant to a court order.
Okay, thank you, Michael. And we'll have plenty of time at the end of this for questions, so I appreciate your presentation. So I want to talk briefly about some statewide data collection and analysis of the conservatorship tool, specifically who's using conservatorship, where, and with what outcome. So last year, I supervised a research project that I had submitted to the Fels Institute of Government at the University of Penn. And the objective of the project was to quantify the impact of conservatorship, because we knew that it was being used in certain counties across Pennsylvania, but I was interested in seeing how often it was used and who was using it, right, to see if it was different from county to county and what the impact was, especially given the fact that the 10-year anniversary was coming up. So through the Housing Alliance and with the cooperation from Fels Institute, I submitted a research project, and they accepted, and 2 students, Rose Kim and Palin Gond, were assigned to work on the project with me. I also had assistance from a graduate student at Columbia whose name is Melanie Lacey. She was in Columbia's Graduate School of Architecture, Preservation, and Planning. And she had done prior research and published an article on conservatorship in PA. And these 3 students were really terrific in terms of gathering data and analyzing it in terms of what the impact of conservatorship has been. So a couple of data points that I want to share with you. And first, just to go back, part of this was to quantify the number of petitions that were filed, but also to see, once a petition was filed, what was the outcome? Did owners step up to comply with the code and renovate their properties, or was it necessary for the conservatorship to proceed to the end where the property was rehabbed and sold, or demolished and sold to a new owner? Because again, the tool is designed for long-term vacant and blighted properties, and oftentimes that the need there is to transfer it to a new owner because the prior owner has had multiple opportunities to bring the property into compliance, and they just haven't for a variety of reasons. So here, this slide shows the number of petitions that we were able to confirm in Pennsylvania. And let me just explain that a little further. In Pennsylvania, we learned that there is no statewide civil case management system. So it was necessary to go to each of the courts of common pleas in Pennsylvania to get some sense of petitions filed. And even at each court, it was not a simple process to review or determine how many had been filed. So we understand that this, in all likelihood, does not represent all of the cases filed from 2009 to 2017. In fact, since the students prepared their papers, I've had contact with other attorneys who said, oh, I had one here, and we hadn't seen that. A lot of the information was gathered by talking to the prothonotary at the court, reviewing dockets, and having email and phone conversations with attorneys that we knew were working on conservatorship actions, as well as the Housing Alliance had sent out a survey to redevelopment authorities and housing authorities in the state and asked for information. So from that data, these are the numbers that we gathered. And again, it's not, it certainly is not complete. But what was interesting here is that you look at the number and places where, the number of counties and places where petitions have been filed, and you see that there is a large number filed in Philadelphia and a large number filed in Allegheny County, and then you see sporadic filings in other parts of the Commonwealth. So that was interesting to see generally what the numbers are and how petitions are being filed. This next graph shows the numbers by year of petitions that we found and when they were filed. And of note was that in 2014, there were amendments to the conservatorship law that made it more attractive to potentially to developers who would be willing to invest the dollars and time and energy to take on conservatorships with petitioners, and that increased the number of petitions filed, as you can see, 2015, 2016. This next chart was really of interest to me as well, to see who was using the tool. And you see that because the Philadelphia and Allegheny County had such a large number of petitions, we found that in those municipalities, those petitions were being filed by non-governmental petitioners, meaning it was either a neighbor, a CDC, or another nonprofit that fit within the definition of parties that had a right to bring these petitions under the law. So that was interesting. And when you look at the breakdown, you'll see that one of the conclusions we reached was that, in those two municipalities, most of the time the petitioner was non-governmental, but in the other parts of the Commonwealth, almost universally, the petitioner was a governmental entity. Here's just a chart showing some of the case outcomes where petitions were withdrawn. Many of these petitions are still pending, and others were settled. Other petitions were denied, and some the conservatorship was granted, but it was still unclear what the outcome was. So some of these dockets were not, we couldn't look in detail at every single petition and all the dockets in line. So this really just gives you a snapshot of some of the case outcomes. So here again, talks a little bit about what was proposed in the plans in counties outside of Philadelphia and Allegheny. And you'll see that for most of them it was rehab of the property, and then you see that demolition was 20%, and then unknown was the 20%, or unknown was also 20%. And what was interesting was to compare the demolition numbers outside of Philadelphia and Allegheny counties and compare it with Philadelphia and Allegheny, and you see that there's a greater propensity, especially outside of Philadelphia, to demolish as an outcome and through the plan proposed in a conservatorship petition. This next slide is one that is of most interest to me because it looks at what some of the data points that you want to look at when you're thinking about this as a remedy and its impact. And this was put together as part of Melanie Lacey's report. And she looked at 20 cases that had actually been conserved in Philadelphia to come up with these data points. And if you take a look at it, there's a couple caveats that I'll mention to you. But what interests me was a lot of the times these properties have tax liabilities on them. And in some places, governments are willing to extinguish those liens, and there's negotiations to extinguish those liens and allow the property to move, but not always. So she looks closely at the average amount of tax and other liabilities that were recovered, and you see that was close to $13,000. So that's a benefit to the taxing bodies and the authorities that had, claims against these properties. And then you look at the average conservator's fee, it's only $17,000. And you look at the impact on market value. And again, Melanie had stated that this coincided with some other work in Pennsylvania that impacted market value. There was a thing called an actual value initiative, and that may also have impacted these numbers. But even if it did, there's some correlation that you can draw from the impact of conservatorship on properties. And again, average property type, row house, distance from center city 5 miles, and then you look too at the neighborhoods. It's helpful to look at that. And this is just another snapshot of how conservatorship is impacting property values, not only of the conserved property, but the larger impact that it can have beyond just that one property. So that sums up my my presentation on these, the overview of the numbers, and I'm going to turn it now to Michael, who's going to talk a little bit about some of the cases he's worked on in Philly.
All right, great. Thanks, Winnie. And I'll do this quickly so everyone else can jump in and communicate. So the first one is 2318 St. Albans, which is one of the most unique blocks in the city of Philadelphia. It's one of the garden blocks. There's only a few left in the entire city. And it's historically designated. So we use the act with a petitioning neighbor who is also actually a lawyer and an estate lawyer who is into historic preservation. And he was upset about this property a few doors down from his house that was in complete disrepair. So we used the act to bring an action against the owner, who had dreams of renovating it for 20 years, and it just kept getting worse. So we filed a petition. We met with the owner several times, and at the end of the day, the owner realized he's never going to be able to renovate this property, and it would be best to just have a settlement whereby he gets a fair market value for the property, and my client was able to purchase it and complete the renovation, which has now been completed and sold to a family that's living in the property. It's a beautiful house at this point. Let's see if I can't click it. There we go. And as you see, it really is. It turned out beautifully. And I believe it was up for a historic preservation award. I'm not sure if it received one. But it was a great use of the act to save a historic property. The next one is one that we are actually finishing up in Queen Village, which is located in the South Philadelphia, and this property actually abuts the Mario Lanza dog park. He was from South Philadelphia. It's one of the few buildings left in this area from the 1800s of this design and Flemish bonding, and it's a historically certified building. This is one where we're taking it through full renovation to make it a new 4-bedroom, 3.5-bath house that will be listed for sale after a year of renovation next month. It was a group of neighbors who live in the neighborhood. They formed an LLC to bring an action as a company, so they weren't using their individual names. And the petitioner proposed themselves to be the conservator. The family here, this was one of those estate situations where the heirs were living throughout the East Coast, and one of the heirs is actually in a nursing home outside of Philadelphia. But the title goes back decades, and we've cleaned up the title through the Act 135 process, renovated the house, and it will be listed for approximately $1 million next month. I don't have updated photos of that one yet, but it really is it was great to be able to save a historic building. This is actually two properties, again, tangled title. The owners came over from Italy in the early 1900s, bought these properties, and title never transferred out of the owners into their children or grandchildren. And the properties just looked like a hulking shell, but when you went inside, all of the beams had snapped, and it was essentially imminently dangerous. That owner agreed to, as often happens when you bring one of these cases, the owner doesn't like the person that brings them to court. So we resolved it by the owner sold it to a local developer who he knew and he was friendly with, and we were able to work just a 3-way settlement where the conservator got reimbursed. The petitioner, I should say, because the conservator wasn't appointed. The petitioner got reimbursed his costs and expenses of bringing the action, and a petitioner's fee for bringing the case, and the property got sold to a competent third-party developer who has since demolished the two buildings, and is rebuilding 2 very nice single-family houses there as we speak. And that's what the site looked at the beginning of last summer, and now there's houses that are being erected. And this is the Point Breeze neighborhood of Philadelphia, which is a transitioning neighborhood where there has been a lot of neglect over the years, but there's intense pressure to revitalize the neighborhood. And properties that people had walked away from 20 years ago or 15 years ago are now actually very valuable. So this property was a 2-story, it was a 3-bedroom, 1-bath house that was another estate issue where somebody died, no will, the family was fighting over who actually owned it. It was unsecured, it was collapsing in the rear, and the neighboring property owner here to the left had a beautiful new construction house, and they were dealing with squatters next door, vermin, water infiltration because of this abandoned house. And it was a young husband and wife that brought the court case, and they proposed, not being the conservator themselves, but they requested one of my nonprofit clients to take the role of conservator to rehabilitate the property. And conservatorship was granted by the court, and that property was completely rehabilitated and sold after rehabilitation. And I think the next photo is a picture from the MLS listing of just some of the updated look to it. And that property has a nice new family in it.
Thanks, Michael. Now I'd ask Alicia to share her use of conservatorship for the city of Bethlehem.
Good afternoon. The Goodman Building is located at 3032 East 3rd Street on the south side of the city of Bethlehem. This is in the heart of our south side commercial district. The city of Bethlehem is divided by the Lehigh River, and we have a north side business district and a south side business district. The south side is a more eclectic area of the city. We've got a lot of personality to the south side. It is surrounded or was developed around Bethlehem Steel, which brought a lot of different populations as workforce into the community. And so you can find all kinds of interesting, fun things to eat and do on the south side of the city. It's a burgeoning arts and music district, and this building is located in what we call the heart of the South Side Arts District. This property first came on our register. If you can, I can't move the slides first. Oh, there we go. First came on our attention, or first registered with us in about 2014, 2015. It was purchased by a Lehigh professor in 1986 who had family ties to the property, and he was a physics professor. He really wasn't an entrepreneur. But what he did was operated a flea market, which he thought was highly successful, for about 5 years in the mid to late 80s. But from 1991 on, the property was largely vacant. He was using it as storage, which was honestly lucky for us because he had a use associated with it. We were able in 2015 to start citing him for having a building that was not code compliant and using it as a storage facility. So we issued 63 citations between 2015 and 2016, all of which this property owner appealed. So in April of 16, we decided to certify it as blighted. We weren't really sure what direction we were going to go, but we had discovered in the middle of that year that the roof had collapsed. We were seeing damage on the adjoining property. There's not really a party wall, but a wall that actually supports the infrastructure of the adjoining building. And so once we realized that there was water leaking into this property and we had a significant roof collapse, we knew we were at a point of needing to make a decision on what to do. So we invested $137,000 of emergency repair funds into the property using our CDBG funds, and really decided to pursue both paths, decided to pursue both eminent domain and conservatorship on the property. So when we're thinking about eminent domain, the building had an adjoining vacant lot. There had been a separate property on this lot. It had burned down and was demolished. It was so long ago, I don't really have a solid understanding of what happened with the adjoining property, but Mr. Konofsky owned both of the building and the adjoining property. And so we blighted the building first with the intent of possibly taking it through eminent domain, and then blighted the lot second. We knew the building had about $200,000 in IRS liens on it, and we're very conscious of the cost it was, or with the funds that it would take us to acquire the building, make the repairs that were necessary, and we're really struggling with what direction to go. So then we decided to move into conservatorship, or at least file the petition for conservatorship at the same time. We knew the benefit of conservatorship would largely be that we did not have to spend the funds to acquire the property. We could put that on the development community. And so we filed the petition for conservatorship, and then almost immediately solicited proposals from the private sector on how to redevelop this property. The city was granted conservatorship in October of 2016 and then started to entertain those RFPs I mentioned. It didn't take us long because we really didn't have a plan for the property. We needed the private sector to help us develop that. And so we selected a developer's proposal that we thought best fit the need of this community and the needs of the city to rehab the property. There were a lot of factors that went into consideration. But it was an entity called C3, a new LLC, Collaboration 3, C3 for short. And what they determined they wanted to do was renovate the existing structure. This is in the heart of a historic district on the south side, and so we knew the demolition would be a really tough road. We did not want to work with a partner whose intent was to demolish the building. Bethlehem is very much known for preserving properties, and so for the city to lead an effort that would have seen a demolition was a struggle for us. And so he came back with a proposal that included renovation of the existing structure and an adjoining building on what was the vacant lot, or what currently is the vacant lot. We had that plan by the developer approved by the courts in May of 2017, and then the sale of the property was immediately approved, but not without a hitch. So the court actions continued with this property owner. He continued to appeal every decision that was made, and it was not until last month that we received the denial from the PA Supreme Court on the transfer of the property. So he had petitioned both, or he had appealed both the decision by the local courts to award conservatorship to the city, and he appealed the decision to sell the property to C3. So the private partner, C3, didn't really want to take possession of the building with this appeal still hanging over their heads, and understandably. And so this delay essentially caused a huge problem for the city. The private partner was all in with us, except all in to the point of having to spend their own money before acquiring clear title to the property. So that, as I said, was finally something the courts had ruled on for us in our favor last month, and we're currently circulating a agreement of sale. In the interim, we have invested another $800,000 into the property. Some of it is a grant, some of it is a loan to C3. That would have been forgivable if the property was unable to be transferred. You can see in this photo there's no roof on it. That roof was taken off and rebuilt. The floors were demolished. The mold in this building was extensive, and so they had to remove the plaster and lath and the flooring on the entire inside of the building. And so we're optimistic that we can get this property transferred this spring, and we'll leave the conservatorship on the property until we see at least substantial progress, if not completion of the building, before we go back to the courts to remove the designation. Thank you.
Thanks so much, Alicia. Now I'm going to turn it over to Sabreena, who's going to share some of her work looking at case studies in the city of Pittsburgh and Allegheny County. Thanks, Sabreena.
Hello. Okay, so just to provide a little bit of background, I was hired on by Pittsburgh Community Reinvestment Group in the city of Pittsburgh to do initially a best practice guide around the conservatorship law. But as I started to get into it and started to learn the process, I found that there were a lot of misconceptions about the law. One of the biggest ones being that this was an opportunity for outside investors to come into communities that might be gentrifying soon and to just buy up property without community interest in mind. And so although that was a valid concern, considering how complex the law can be, just from the things we've talked about already, some of the facts can be so cold and so difficult to understand that I thought that and other misconceptions were valid. And so as I started to talk to people, I started to sort out those misconceptions. I started to learn more about the law, but I realized that it was hard to get people who had gone through the process to readily open up and start to talk about it. And so I called it, in the beginning, harboring the secrets of success. And so it was difficult to get people to kind of just expound upon what the challenges were, what the difficulties were, how they got around certain issues. But then as I started to build relationships and I started to understand why, and I started to understand the attachment to remediating blight and its impact on communities, I started to understand, and at that point I couldn't get people to stop talking. about its use and things like that. And so I decided to create something that differed from what was already out. And I wanted to do more of a journalistic approach to conservatorship, thereby giving it a face and making it more personable. And so I built off of the foundation that Judy Berkman in Regional Housing Legal Services had laid and that the Housing Alliance had built off of to create manuals and things like that. And I created this conservatorship, the 10 years of productive reuse, to kind of build a story around conservatorship that would provide the facts, but then also provide the realities of how it's been implemented by individuals, community-based organizations, and the like, and then also develop policy recommendations that I thought would fit with some of the challenges that I had experienced through the conservatorships that I had spoken with. So one of the case studies that I talked about in this publication was a Sheridan community garden. And so briefly, there was an individual living in the Sheridan community, and next door to him was a property that was in extremely poor condition and was set to be condemned by the city of Pittsburgh. So I'll go back to that picture really quickly. So on the left side, you'll see that this is the structure here, and you'll see that there's like rotting wood and tiles. It was, the window in the front was boarded up, but previously it was an open entry point. You can see the overgrown vegetation here on the porch, and like looks like it's lifting the porch and things like that. So the case was filed, the conservatorship was granted, there was a plan for reuse in place, and the conservators wanted to demolish the property and put in a community garden, and that was approved. And so all that work was completed and it was up and functioning by 2015, but the case didn't close until 2018. So to back up and I want to talk about why that took so long. And so, like I said, the property was eligible for conservatorship because of the overgrown vegetation for one, and this is amongst other things. I just listed these three. But it was also an attractive nuisance, and so there were reports of people hanging out in and around the building. People were discarding trash and things like that on the property because they saw no value in it. There were open entry points, as I stated, and the owner no longer had any interest in the property and was just going to let it, whatever happened, happen to the property. So I stated before that the conservator decided that he would go through the demolition route with this property, and that was approved. But demolition of homes and structures isn't always the best approach to addressing blighted and abandoned structures, but sometimes it's the most reasonable option. So especially in densely packed neighborhoods like Pennsylvania's communities, where a few missing structures can make neighborhoods look like they are missing important features to them. They look incomplete. And so it's difficult for the city and government authorities to see the value of empty parcels, especially when considering the loss to municipalities and school districts, when considering like the liens on the previous structure. And so, but the value in that reuse plan was, at the time, Sheridan was recognized as a food desert. And so the garden, the conservator thought, would appropriately address and foster community in that area by teaching the children how to plant, the value in planting your own foods, and allowing it to be a free garden where people could grab things from it. And this conservator was experienced in demolition, construction, and farming and gardening. So he made a good fit for this type of reuse plan. So the termination, again, took 3 years, the termination from conservatorship, that is. So basically, after the property was turned into the community garden, the conservator also had interest in purchasing the new garden out of conservatorship as a side yard. And he and his lawyer were hoping that the conservator will be authorized to take ownership of the property free and clear, which is allowable in the law. And so the attorney expressed that it'd be judicious to have the taxes forgiven, relying on the reality that the work that the conservator had performed relieved the city of Pittsburgh of time, money, and resources, which would have been associated with that condemnation process. And so under a free and clear sale, the court can agree to have the property sold free and clear of all the liens, claims, and encumbrances against the property. But the courts ended up denying that request because they have the right to say yes or no to that. And so they chose to say no because they thought that the liens would have been of value to the city of Pittsburgh. So in 2016, they were requested to show cause as to why, And again, they denied that request because they have the right to collect those liens, and so they wanted that to happen. However, in 2000, the city and county attorneys decided eventually that they would compromise the real estate tax delinquency as a unique exception in consideration of the amount of money that the conservator had put into the rehabilitation, how those efforts, they did end up seeing how it was a benefit to the city and county. So in 2018, that conservator was finally granted conservatorship over the property. He did come up with the agreement that he would void his conservator's lien as a show of good faith and a way to kind of get the process going for him to get ownership. But that case did end up setting a precedent, which was good moving forward in other conservatorship cases with regards to tax compromise. And so here you can see in this picture what the community garden looked like from that picture that I showed before of that deteriorating building. This is the community garden in its earlier stages, and it did end up being a big having a big impact on that community. And so another case study that I focused on was the rehabilitation process. And so you can see here in the left pictures, you can see the work that's being done on the siding of the building. You can kind of see in the top the chimney work that had been done to work on that. And then in the front, this is kind of like what the new face of it looks like and the work being done there. So the backstory of that, there was a couple living in Pittsburgh's Manchester area. And when I say it started with bricks, there was a lot going on with the house initially. There was clear evidence of drug use happening. The chimney was deteriorating, and so one of the final steps for that couple was the bricks that were falling from that deteriorating chimney were falling close to the couple's car. And again, this is another one where the conservatorship process would take them on a journey that was way more than they had intended. So always the intention is to bring a property up to code. But as a lot of conservators find, it's not as cut and dry, and it's not as simple as just looking at the law and following it step by step. There's always some issues that you run into, but I wanted to focus on this case with the rehabilitation process because these were individuals who were able to go through the process on their own. And so they ended up bringing up this property. Their case closed in 2017 after being started in 2014, and their plan was to rent out the upper level of the property and then have the lower level be an Airbnb-style rental. So the eligibility for that was that the owner was deceased, which means that it wasn't being actively marketed. It was a hazardous property, and it was an attractive nuisance with the drug use and weaponry that was found on the property. With an individual tackling conservatorship, this is one of the first cases in the city of Pittsburgh, and so at the time the city didn't understand that process, which made it difficult for the conservators, who are also the petitioners, to understand the process and kind of be in agreement with the city. So they had to create a method with not many examples to look to. So as I talked about in the last case, there is demolition and there is value in demolition, but the value in the reuse plan that they had, it kept the property in the housing stock. It increased the value of the surrounding properties, and they were appropriate conservators because they knew the community and the people of the community and the Community Development Corporation very well, and they had a direct interest and willingness to handle that project. And so one of the things that I focused on was kind of like this conservator's advice that they had, and one of the things they talked about was that starting with the proper team. So not starting with the proper team, the people that you have in your initial plan are going to be the people that are integrated throughout the entire process. And so they were talking about how they were working with a 100-year-old building. It took them a few tries to get it right. Their team changed a lot, but everybody on the final team understood old buildings. And so she gave some tips on how to save money by buying your own materials. And really this information is useful for individuals who I feel like sometimes get overlooked because community-based organizations are typically the ones we see using this practice. But I thought their story was pretty good. And so when developing a reuse plan, one of the things that we had ended up working out was that to think about, do you have the skills or proper resources to handle the project scope? Have you created a budget plan that includes legal fees, Do you know what the project scope needs? Things like architects, contractors, engineers, materials, permits, etc. Can you carry out your plans in a reasonable time? And that's really important because conservatorship isn't intended to last forever. So you want to remediate the property and take care of all those issues that were the reason why the conservatorship was granted in the first place. And then thinking about if you have enough support to throughout the process to get it done. And so I focused on those things as an overview of the process to kind of get really into it and kind of create a realistic portrayal of conservatorship aside from just here are the facts and here's the law. And I thought that and it was a really good journey to see conservatorship inside of the process.
Thanks, Sabreena. And just to sum up, a lot of the case studies we shared today were from government, were from neighbors, from nonprofits. CDCs are also petitioners in Philadelphia and in Pittsburgh. And if you look at Sabreena's publication, which you can find on PCRG's website, she talks more about the East Liberty Development Corporation's efforts on conservatorship, and I know they had presented frequently on their use of that tool, and there's some webinars that Kendall Pelling participates in that are on the Housing Alliance's website. You can find them easily. And then in Philadelphia, Mount Airy USA, same thing. They use the tool, and that's a good, they have good examples, too, of how to use that tool if you're a CDC. And because those folks had presented before, we wanted to share some different examples through this webinar and the presentation we gave at the Homes Within Reach conference. So right now, I want to open it up and ask if anyone has any questions. I'm looking, Colleen. I don't see any questions typed in the chat box. So I guess you're going to open up the lines and have questions.
Sure, yeah. So if you do have any questions and you'd like to ask them over the phone, please press *7 on your keypad on your phone to unmute your line. There was a couple of questions, Winnie, that came in about Cindy was asking that you can't, she wanted a clarification on not purchasing the property to keep it as a rental, that you are required to sell a property no matter what.
Okay, I see this. Looks like you cannot purchase this to keep the property as a rental. You are required to sell the property no matter what. I'm assuming you are required to pay all liens against the property. Michael, do you want to talk about that, or did you answer this?
I would love to jump in on that.
Okay.
So you are not required to pay all liens against the property. When the conservator is done doing their work to remediate the condition, the property is listed for sale and sold. The court order technically will sell the property free and clear of all liens and encumbrances. As a practical matter, at least in Philadelphia, the judges will require that all municipal liens get satisfied at the time of the sale. She will not discharge them here at this time. The city has not and refuses to negotiate on any real estate tax liens, even on properties that are, I'm dealing with one right now where we're conservator of a property that's assessed value is about $8,000, and it's a house. The city's owed $18,000 in taxes, and they still will not release their tax lien. So it's kind of a discretion of the judge a little bit. The judge doesn't have to discharge all liens, but under the statute, all liens are discharged. You're selling the property free and clear of all liens. Like today I was in court on one where a mortgage company had a $385,000 mortgage. At the end of the conservatorship process, after paying taxes, realtor fees, my fee, and the conservator's fee, there was $133,000 left. So their lien got discharged. I sold that property 2 months ago, and they had to come back to the court to prove that their mortgage was in excess of $133,000. Under the statute, there's a priority, an order of distribution for lien holders. The mortgage company was the primary lien holder, so they got all of the remaining balance. Not their total lien amount, but whatever was left. As far as buying the property or keeping the property as a rental, we have one that's coming up. It hasn't been decided yet, but where the judge is considering if the conservator gets an appraisal of the fair value of the property and they're willing to pay the fair value of the property, that they could keep it that way and maybe discount, you would deduct your conservator's fee of 20%. But at the end of the day, the conservator only takes possession. They're not the owner. So the judge, at least in Philadelphia, wants to make sure in most cases that it's getting sold for a fair value, liens are getting paid, and the owner is getting what's left. But we have had cases like the case that we just talked about the garden, where a nonprofit asked for a vacant lot next to them that's been trash strewn to basically be given to them for $1. And that was approved by the court. But that's the exception, not the rule, I would say, at this point.
There was a question from Noble. How did the Bethlehem commercial property deal with IRS liens through the conservatorship process?
We had actually started to negotiate with the IRS without knowing if we were going through conservatorship or eminent domain, and we were able to negotiate a reduced fee, or a reduced lien, I should say. And so those funds haven't been dispersed yet, but we essentially just sent our solicitor's office to the IRS office in the city and said, hey, can we talk? And so they were able to strike a deal.
Great, thank you. And there was a question from Joyce. Is it difficult for a successful conservatorship in a low-income neighborhood? 2 properties were submitted for conservatorship in East Parkside, but it seems that the market value doesn't make a conservatorship attractive.
I can try this one. And so I wrote a little bit about this. I wouldn't say that it's not possible for a successful conservatorship because you can repair the house. However, like you were saying, it seems that the market value doesn't make the conservatorship attractive. That's true, and that's something to consider, because if you invest a lot into this property, you may not sell it as high if no one's interested in the neighborhood isn't as attractive and no one's investing in that neighborhood. So you fix up a property, it gets to a certain value, but no one's still interested in buying it because the neighborhood's market isn't interesting.
Yeah, this is Mike. I agree with that. I always tell my clients, whether it's an individual, a developer, or my nonprofit clients, you have to start with the end in mind, and after you do the renovation, how much is the property going to sell for? And then you back out the attorney fees, the filing fees, you might not have a conservator's fee. If it costs you $40,000 to renovate a property to make it like a safe, stable shell, somebody might not pay for that. They might only pay $20 in that neighborhood. So that is an issue. One of the ways we're dealing with that in Philadelphia, the property I just referenced with the large tax lien, the neighboring property is a developer who is willing to basically contribute the money just to fix the problem. And we have a couple other large developers that are willing to do like a Habitat for Humanity type model, where they will take on the property, not anticipating getting a conservator's fee, and in some cases actually losing money just to be able to transform some blocks. And the conservatorship will give them that tool. But if they're trying to get their money out of it, the first thing you have to do is make sure that it's going to sell for more than you're into it for. And so low-value neighborhoods, it does become a problem.
Great, thank you. And there was a question from Joshua. What kind of financing for repairs did the different cases use, especially in the Philadelphia cases?
That's a great question. So we generally, on every one of the properties except for the 224 Catherine in Queen Village, it was cash. The conservator just has cash available to use on hand, so we're not having to get financing or go through banks. We can just write a check. On 224 Catherine, the renovation cost there was a lot. It's a group of neighbors that banded together to do the project, and we had to go to the court to get financing approved. The court in Philadelphia is hesitant to approve financing. The general thought is you shouldn't be doing it if you need financing, like have somebody else do it or use cash, because you're getting a 20% conservator's fee, and the judge doesn't want to see interest rates that are taking out of the owner's proceeds in addition to the conservator's fee. But we did get a hard money loan. Traditional banks generally won't fund it, or I've had trouble at least getting it through the underwriting. A hard money lender did fund it, and the court did approve it at a reduced interest rate. Hard money loans in Philadelphia right now are 11 to 15%, and we got a lender to go down to 9.25%. And the judge, with that concession, the judge approved the loan, and we had the support of the family to take out the loan. So we have a loan for $450,000 to do the renovation, and at 9.25% interest. So it can be done. All financing has to be approved by the court. So that adds an extra layer of complexity if you do need financing for your proposed plan.
And this is Winnie. Just from conversations across the Commonwealth, financing of repairs is a major challenge to using conservatorship as a tool, especially in low-value neighborhoods.
Great. There was a question from Tricia. Where in the statute does it authorize the conservator's fee? And Sabreena, you said that that is in Section 5G, the conservators and developers fee. There was a question from Barbara. Do you have a primer for commissioners or council to explain this as in layman's terms?
I would suggest that you go and look at the Housing Alliance's publication From Blight to Bright. There is a chapter on conservatorship that is 3 pages, and it's very concise. It answers some critical questions like, what does it do? How do we pay for it? And I would start there, and then if you want to dive deeper, the Housing Alliance's website, pablightlibrary.com, has a link to a bunch of other resources that go into more detail about using the tool.
Great. And the last question from Joyce is, what other advice can you give a nonprofit CDC on how to do low-cost conservatorships in a neighborhood with many at-risk blocks and abandoned properties, but the neighborhood is expected to transition because of numerous cultural assets, locations, etc.? Can you recommend possible partners in Philadelphia? This neighborhood would be East Parkside.
So East Parkside would be over by the Please Touch Museum. So we actually have some projects that are going on right now that haven't been filed yet, where we have been contacted by some neighbors to look into using the act in East Parkside. I represent the Philadelphia Community Development Coalition in the majority of the conservatorships, and they have been approached to do some in that neighborhood, as has one of my other clients, which is the Commonwealth Preservation Alliance. So we are exploring how to bring it to Parkside, and it will be an issue because the cost of the renovation versus the value of the property can make it tough, but it is actively being pursued, and I guarantee you we do one in the next 3-4 months just to give it a try in that neighborhood.
Great. And the final question is from Noble. In the cases of for-profit developers partnering with individual petitioners, who should be named conservator?
Well, what we did with Bethlehem, was we had the city named conservator, not the private sector partner.
So this is Mike. I always would recommend, if you have private individuals that would be considered being conservator or the nonprofit, I would always recommend that the nonprofit be appointed conservator because they have a higher priority. If what sometimes happens in our cases, not often, but people can intervene. Another nonprofit could intervene, possibly with the consent of the owner, to try to knock out a neighboring person that wants to be a conservator, and under the statute, a nonprofit would be given priority over an individual. So I would just look at that as why I would say the nonprofit should be given priority. And if the township, if the city, or the municipality wants to do it, they would be above a individual for the first right to be the conservator.
Great. And there was a follow-up question to that from Barbara about can a township be the conservator, but we just answered that a municipality and a nonprofit would be prioritization. And could you just repeat quickly the 2 organizations doing conservatorship in East Parkside?
So it's the Philadelphia Community Development Coalition. And then the second one is investigating or has met with some neighbors is the Commonwealth Preservation Alliance.
Great, thank you. And so we're going to end today's webinar. If there's any last-minute comments from the presenters, you could do that now.
If anybody wants to read that publication, the 10 Years of Productive Reuse, I'm just putting the link in the question section.
Yeah, this is Mike. I would just say from one of my comments that I put online is, in addition to the slides, we should circulate a copy of the actual statute. It's not very long, and a layperson can flip through it and get a pretty good feel of the statute. And if you need anything, any other questions, I would say email any of us with your questions, and I'm sure everybody will respond with thoughts or feedback.
Great, thank you. And thank you to all of our presenters and all of our attendees. As I mentioned at the beginning of the webinar, we will be sending out the slides, the recording of the webinar, as well as the additional resources that we just mentioned by the end of the week. Thank you, everybody, for joining, and thank you again to all of our presenters.
Thank you.
Thank you.
Thanks.